Ready? Exercise number 28. Legal matter. Start. Leave granted. With consent. The appeals were heard finally. The present appeals by special leave impugns 3 order of the Telangana High Court dated 28/8/2018, 22/7/2019 respectively. These were in the context of the respondent writ petitioners under bracket hereinafter Andhra Petro bracket out challenge to orders of the designated authority under bracket hereinafter DA bracket out, which related to the question of imposition of anti-dumping duty. Stop, next para. The facts are that Andhra Petro applied to the central government seeking imposition of anti-dumping imports of normal butane or N-butyl alcohol originating in and exported into India from Saudi Arabia. Ethanol is a basic organic chemical and a primary alcohol. It is excellent solvent for acid curable liqueurs and baking finishes. A large part of normal butanol is converted into derivatives for use as solvents in coating industries. This application resulted in the initiation of investigation by the designated authority into the import of the subject articles from Saudi Arabia by notification dated 2/9/2016. Andhra Petro asserted that the exports from Saudi Arabia into India were not casual exports but were made with the intention of grabbing the Indian market. Such exports into India from Saudi Arabia were undercutting and depressing the prices of the domestic industry to a significant extent. According to it, and performance of the domestic industry during the period January to March 2016 was adverse in terms of investments. The following parameters per the petitioner company demonstrated the causal link between the said exports and the injury caused. The dumped imports from the subject country entered the Indian market in the period January-March 2016 in such significant volumes that improvement in volume parameters seen in the performance of the domestic industry in the first 9 months of the POI was completely wiped off. There was significant difference between the prices offered by the domestic industry and the foreign producers. Thus, the domestic industry was unable to raise the prices above the cost as a result of dumping of the product in the country. Stop, next para. The High Court disposed of the second writ petition on 28/8/2018, making the following observations and directions. Quote, next para. Domestic industry means the domestic producers as a whole engaged in the manufacture of the like article and any activity connected therewith or those whose collective output of the said article constitutes a major proportion of the total domestic production of that article except when such producers are related to the exporters or importers of the alleged dumped article or are themselves importers thereof, in which case such term domestic industry may be construed as referring to the rest of the producers. provided that in exceptional circumstances referred to in sub rule 3 of rule 11, the domestic industry in relation to the article in question shall be deemed to comprise two or more competitive markets and the producers within each of such market a separate industry. The producers within such a market sell all or almost all of their production of the article in question in that market, and the demand in the market is not in any substantial degree supplied by producers of the said article located elsewhere in the territory. Stop. Next para. In the light of the above, this writ petition is allowed, setting aside the order of the second respondent dated 5/3/2018. The second respondent is directed to take steps for initiating investigation to determine the anti-dumping. Stop. Thank you very much.